Welcome to New Laws with Gov Hutchinson. We're so lucky to have such an accomplished speaker here today. I'm Lisa Dunn, Chair of the Orange County Realtors Risk Management Committee. It's my privilege to first welcome our 2021 President of Orange County Realtors and my good friend, Lori Namazi, who will be moderating today. Take it away, Lori.
Thank you, Lisa. Good morning, everybody. We are so thrilled for you to join us today for our first Risk Management Forum of the year. We are honored to have Gov Hutchinson here today, and I would also like to acknowledge our fellow officers. We have our immediate past president, Danielle Corliss, joining us. We have our 2021 treasurer, Joyce Endo, and our 2021 president-elect, Adam Rodell. We had over 1,000 registered for our session today, and that includes some of our friends from the Bakersfield Association of Realtors. So welcome, President Rhonda Newport, and from Mammoth Lakes Board of Realtors, President Karen Nelson. Thanks, you guys, for joining us. We're honored to have you today. So welcome. So before we begin, let's salute our flag. We'll put a flag up on the screen, and if you can put your hand over your heart, we will say our pledge. All right, ready, begin. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Thank you. And so we want to take a moment to thank our webinar sponsor today. We have Robert Ross from Reverse Mortgage Educators, and he's today here today sponsoring our webinar, and I'd like to give him a couple moments to say a few words to the group.
Sure. Thank you for the introduction, Lori. Good morning, everyone. My name is Robert Ross. I'm with Reverse Mortgage Educators, and I just wanted to share with you three brief items here that I think that help realtors generate listings with reverse mortgages. So the first one is that a lot of homeowners right now are getting advertisements about reverse mortgages on television, radio, etc. And they're going to start asking more and more realtors about this product. And it's important for you guys to have a little bit of education on it for that reason alone, so you can be a value add to your customer. But one thing I want you to really perk up on when they ask you that question about a reverse mortgage is that they're not really asking for a reverse mortgage per se. What they're saying to you is that I'm tight on income, I have equity in my home, and I need some help. That's what they're really saying. So perk up when you hear those questions, because one thing that I do know is that only about half the people that inquiry about reverse mortgages actually get them, either because A, something didn't work out, or they owe too much, and they have to figure their solution out a different route, which most likely will turn into a listing at some point. So it's important to insert yourself in that regard. Number two, there's a lot of customers right now or people in your spheres that are on the fence right now to list their homes that are older. And they're looking for that one bit of information that's going to help them get over that hump and list that home and get to that retirement home or that downsized property, so to speak. And that would be perhaps mentioning the reverse mortgage for purchase product, because a lot of homeowners are trying to figure out how to sell their home, get that equity out, put a roof over their head, and put some cash in the bank for retirement needs. And that reverse mortgage purchase can help do that by taking up some of the slack on the purchase side of that transaction when they buy the replacement home. And then finally, the last bullet is that many homeowners currently that are retired have reverse mortgages in place now. And we feel these are all questions that I've got over the years from many, many realtors. They always ask, well, what happens at the end with the product? I'm talking to a family right now. I needed some education on that. So understanding how the loan works when the final borrowers meet their maker, so to speak, is great for a realtor to know, because you can insert yourselves with those families that have loved ones that have reverses. And when they pass away, you're there to guide them on how to deal with the real estate asset after that's done, either they're selling it, refinancing it, just figuring out how to help those heirs get that property into their possession. So those are the three ways that a realtor could really benefit by learning more about reverse mortgages and, of course, the reverse mortgage for purchase. And to find out more about this stuff, we have a class coming up with OCAR February 23rd from 11 a.m. to 12 p.m. So that's next month, the 23rd at 11 a.m. We cover all these topics in detail. And at the end of the class, we're going to share with you some softwares and some complementary marketing materials to help generate some listings with retired homeowners. So We'd love to have you on that live stream. It is on the OCR calendar, so take a look there, register for the class. It's a good one. A lot of folks out there in the audience today have taken my class, and I think there's some good benefit there. So we'd love to have you, and I'll turn it back over to Lori.
Great. Thank you, Robert. That was some wonderful information for our members, and we appreciate that. And we look forward to seeing your class on February 23rd.
Great. Don't forget, guys, there's also a drawing too at the end of the class today.
Yes, I was just going to mention that. So Robert's company, Reverse Mortgage Educators, is providing a $25 Amazon gift card that we will award at the end of the presentation. And you do need to be present to win. So please stay with us. You do not want to miss the information that is about to be presented. We are so fortunate to be able to get Gov Hutchinson on our schedule a few times each year. And we know that this particular session is always so important because there's a ton of new laws that are signed by the governor each year, and Gov and his team weed it down, pare it down to those that are most relevant to our industry. So please be sure to pay careful attention. We'll post the links in the chat for the FAQs and the new laws, the list of new laws that he'll refer to, and we will be taking questions. Please put them in the Q&A, and we will also have Gov try to answer those ongoing, but we may also have some that are held till the end. So please post your questions. And so without further ado, I'd like to introduce our esteemed speaker today, Gov Hutchinson, who is the Vice President and Assistant General Counsel for the California Association of Realtors. Gov, thank you for being here.
All right, thank you for having me. It's great to be here. Wish I were in person, but actually if I were in person, there probably wouldn't be as many of you I could talk to. It looks like we got 565 right now, which is, I think it's the biggest crowd I've had in years. So it's great to be here. Yes, I especially like Orange County Realtors, but I also especially like Bakersfield Realtors and Mammoth Lakes Realtors. Three of my favorite places to go each year. Now I go virtually, but hopefully one day I think one day we'll be mixing it up. We'll have virtual and live sometimes. Anyway, this is the perfect time of year to do this, obviously, because this is when all the new laws have taken effect. It's also when the new forms have come out, and so we have a lot to talk about. Now, in addition to the new laws that come out, as you've been noticing for the last 10 months, there's COVID laws, and the COVID laws keep changing, and they just change all the time, and they don't wait till the end of the year to change, right? I mean, those rules just keep changing whenever. So obviously you have to be very flexible. I mean, the basic new laws, you usually only have to worry about them once a year, right? Once a year, the regular new laws come out. But then the COVID laws keep changing. You got to be flexible and adaptable the way you've been the last 10 months. It's going to be a few more months of this, right? So you have to keep up with that. In fact, let me start with COVID stuff, and then I'll talk about other stuff, okay? COVID stuff, what's the latest? Well, first of all, I always keep hearing once in a while from realtors, hey, I heard things have changed. I heard I can do open houses now. Well, no, you can't. Nothing has changed. I mean, the basic rules, the guidance put out by the health department under the authority of the governor hasn't changed for months. It's really the same. You cannot do open houses. All showings have to be by appointment, right? And to me, the word open and by appointment contradict each other. You can't have, oh, I got an open house by appointment. Well, is it open or is it by appointment? If it's by appointment, it's not what we normally mean by the word open. So just think of it as you can have showings after showings, as many showings as you want, as long as you allow enough time between each showing to clean the property, and each showing is limited to one buying party. If you do that, you can show properties. And of course, the basic rules haven't changed. You submit the PED form in advance. Everybody wears a mask. Everyone's 6 feet apart unless they're already living together. You don't touch anything. I mean, those basic rules have not changed at all for many months. Actually, and they were reaffirmed. The original stay-at-home order, which has been in effect since March, was actually updated in December, and it didn't really change much as far as realtors are concerned. It changed for other industries, but realtors, you're still essential. You can do what you normally, you can do your normal job, but the order made a couple things clear. First of all, the updated December order, it reaffirmed no open houses. And it also said, second thing, the mask wearing. When you're a realtor or any other someone in business, if you leave your house to work, you're supposed to be wearing a mask unless you are outside 6 feet apart from somebody, or you're obviously driving around your car, that's fine, or you're inside, but you're inside alone. So even if you're in your real estate office, if you're the only one there, fine. Or if you're in your office within the office, that's fine. But if you're in the open part of the real estate office and you're not the only one there, you're supposed to be wearing a mask. And obviously, when you go preview properties or inspect properties or show properties, obviously should be wearing a mask then. Okay, so that really hasn't changed so much. I think one other thing to emphasize is the new order made it clear that realtors are essential, but you're only essential. I mean, you're essential, but that doesn't mean you can do everything you used to do yet. In other words, you're only supposed to be out there doing stuff that you can't do virtually, like showing properties, previewing properties, inspecting properties. That you have to be in person, right? But you're not supposed to do, like door-to-door marketing. You're not supposed to be knocking on doors. That's not considered an essential part of your job that you can't do virtually. I mean, use email, use regular mail, but don't be going door-to-door marketing at this point, okay? All right, so that's the latest on the basic COVID rules. Let's talk about some new things. Speaking of new laws, there's a brand new law affecting this that affects all you guys that work out of an office. And the new rule is, whether you're a brokerage or any other office, and your office is open, and somebody who works in the office tests positive, right? Okay, so what do you have to do? I mean, common sense, I'm sure all year long, you've been, if someone in your office got sick, you'd probably tell them to, don't come into the office, and you probably tell your other agents. But now it's been formalized into a law which says you're a business owner, which means a broker of an office, and one of your people who works in the office tests positive. By the end of the next business day, you have to notify everybody else who works from the office in writing that someone has tested positive who works in the office. And number two, this is what I'm going to do to clean and disinfect the office. And number three, these are your rights if you're an employee. So you got to give this notice to agents, independent contractors, and employees. If it's an employee, you have to tell them certain things, like what their rights are in California under employment laws, such as sick leave and COVID leave. Obviously, you may say to yourself, I don't know exactly what I put in this notice. We have a brand new Q&A on the website. It's called California AB 685 notification to employees. Okay, so that'll sort of give you an idea of what it gives you, a template of what to put in this notice that you have to give to all your other employees. What if you have someone who works for you, but they don't work from the office and they tell you they're sick? Well, you don't have to tell anybody because they're not in the office, right? You only got to disclose people in the office, okay? Well, what if someone in the office tests positive? And by the way, you don't disclose who the person is, right? You disclose that there's someone in the office who got sick. Well, what if someone in the office got sick, but you have got a bunch of agents who never come in? Do I got to tell them? Well, think about it. They never come in, but how do you know they won't decide to come in tomorrow? So you probably should tell everyone who works in the office, even if they don't come in at all, unless you have an agent working out of Arizona or something, you're pretty sure they're not going to come in. So agents who don't work in the office, they tell you they're sick, you tell them stay away from the office. You don't have to tell anybody because they're not in the office. You see what I'm saying? By the way, and if you have questions, I'm already seeing some questions. I'm going to answer your questions, but please put them in the Q&A, not the chat, okay? So I've already seen some, I'm going to answer them in a second, but put your questions in Q&A, not chat, all right? Okay, A related thing, this is not new, but I think you all know this. If you open your office and you allow people to come into the office who don't work there, right? Like, for example, you allow clients to come in or agents from another office, you have to screen them. When they come in, they don't have to submit a PED form. That's only for showings. But you do have to sort of, when they come in, someone has to, everyone has to be wearing a mask. You have to ask them, do you have any symptoms? Have you been near someone who's sick in the last 14 days? And then you have to keep a record that they were there, right? And then you have that record. So then if 2 or 3 days later, within the infectious period of 14 days, they call you up and say, you know what, I was in your office 3 days ago. And guess what? I just tested positive. You now have an obligation as the owner, the broker, the person in charge of the office, to notify everybody else who came into the office after that person 3 days ago came in, right? Which is the only way you could be able to do that, is to be able to keep track of who comes into the office. That's similar to when you have a listing agent, you have showings, right? And you get the PED form, they come in, everything's good. And then 3 days later, the person who you showed the prop, or even you weren't there at the showing, but they were shown the property, and then they notify you, the listing agent, like they're supposed to, hey, guess what? I just got tested positive. Well, now you have to go back and tell everyone who came into the property in the last few days since that person was there. And the reason, and you're able to do that because you have a PED form, right? So that's not new. That's still in effect. You still have to do that. Okay. All right. Next, the last thing on COVID I want to talk about, and I see I have some questions. I'll get to those. I'll do the COVID questions first, is what's happening in the rental situation. All right. Well, the very first day, the day that President Biden was inaugurated, he extended the federal nationwide eviction moratorium. What does that mean for us in California? Okay. First of all, in California, we have the California eviction moratorium, which is scheduled to end January 31st, 10 days from today. I will be stunned if it doesn't get extended beyond that. They've already submitted bills in the legislature. It's very likely it gets extended, I think, for 3 months. So the federal one has already been extended till the end of March, 2 months. It looks like the state one will be extended till at least the end of April. Let's assume that's going to happen. What are the rules you have to know? Well, the basic rule, of course, is number one, if you have a tenant who can't pay rent because of COVID, you cannot evict them yet. If you have a tenant not paying rent for some other reason, you can evict them. Well, how do I know the reason my tenant is not paying the rent? Well, you submit them a notice to, you submit, you give them it's perfectly legal to give them a notice to pay or quit. But you're not going to give them the normal 3-day notice to pay or quit. There's a special form on Zip form. Remember, all these COVID forms are in the same place on Zip form. There's a COVID notice to pay or quit. It's actually a 15-day notice to pay or quit. You submit that form and they respond within 15 days with the declaration of COVID financial distress, you can't evict them. They don't respond in 15 days, you can evict them. Either way, they still owe you the money. And you can sue them today for the money they owe you. But you're limited. You can only sue them for $10,000 in small claims court. And if you've already, and you can only do it one time to do that. But guess what? Coming up in March, landlords will be able to sue tenants for back COVID rent in small claims, even if it's more than $10,000, even if it's $100,000. You can't evict them for the time being, but you can still sue them for the money, okay? And of course, tenants right now have to pay, even if they have a COVID reason, they have to pay 25% of the rent. If they don't pay 25%, you can evict them for not paying at least 25%. You see what I mean? But when can I evict them? Well, right now I would say if you'd asked me 2 days ago, I would have said February 1st. Then the nationwide eviction moratorium was extended. So if you'd asked me today, I'd say legally you can't evict them until end of March. But as I said, I would almost guarantee the state is going to extend it even beyond that, probably to at least end of April. So in other words, you can't evict yet, but they owe you the money. And you can sue for the money today up to $10,000, starting March 1st up to unlimited. Of course, when they extend the law, as I'm expecting them to do, they might change that too. Remember what I said? You have to be flexible when it comes to COVID regulations. Things are in flux always. Just be flexible. And when these things happen, we're going to email every realtor in California, so you'll hear from us. So read your CAR emails about this, okay? So once again, the extension of the federal one. Let me back up a sec. Okay, so now let's talk about, I got a tenant. It's not an issue of paying rent. It's an issue of they have subtenants without permission. They have Airbnb without permission. They have pets without permission. They're causing a nuisance. They're causing damage. They're doing criminal activity. They're not allowing me to show the property. If you got a tenant doing any of those things, you can evict them right now. And even if they extend this law, you can still evict them. How do I evict them? I give them a 3-day notice to cure breach of covenant. But you don't give them the normal 3-day notice. There's a special COVID 3-day notice to cure breach of covenant. Once again, it's on the COVID part of zip forms. Third situation, and this is important. What if I got a tenant and it's not that they're doing anything wrong, I just want them to leave? Can I kick out a tenant right now, even though they haven't done something wrong? And the answer is not right now. And supposedly February 1st, that was going to go away. But since I'm pretty sure it's going to get extended, think about it probably for the next couple months at least. You're only going to be able to evict a tenant if they haven't done anything wrong for 3 reasons. Number 1, the landlord wants to move in, or their parent, grandparent, grandchild, grandparent wants to move in, or spouse. That's an easy way to separate from your spouse. Honey, you got to go live in the rental house so we can kick out the tenant. Anyway, sort of kidding, but that is legal. Then second reason, you can kick out a tenant because you want to take the house off the rental market. But remember, if you do that, that means you can't re-rent it for at least a year. So, and that means if you sell the house, the buyer can't rent it out either. Fortunately, there's a third way that's legal for a realtor, for a landlord to evict a tenant, even though the tenant hasn't done anything wrong. And that is, if you're selling the single family house to a buyer who is planning to live there, but you can't give the tenant the notice to leave until you're actually in contract with the buyer. I mean, just because you have a listing and you're planning on selling to the buyer who wants to live there, you got to wait till you're actually in contract with the buyer. Then you can give the tenant a 30-day or a 60-day notice. Once again, not the regular normal notice to terminate tenancy, the COVID notice to terminate tenancy that's on zip-4. All right. And that's still in effect. And that's even going to be in effect even if the Tenant Relief Act gets extended in California. But there's a catch. Remember I said the federal law has already been extended for 2 months? The federal law, listen carefully, says if a tenant has a COVID issue, you cannot evict them for one of those no-fault reasons. Let me put it this way. Under California law, if you're selling the house to a buyer who wants to live there, you can evict that tenant even though that tenant has a COVID reason for not paying rent. you're saying to the tenant, I'm not evicting you because you're not paying the rent. I'm evicting you because I'm selling the house to a buyer who wants to live there. It's got nothing to do with you're paying the rent. Under the federal law, the same one that's been in effect, that was supposed to expire end of January, that's going to be extended. If someone has a COVID reason and they say under penalty of perjury that they have a COVID reason why they can't pay the rent, you can't evict them for no fault, which means you can't evict them even if you want to move in, take it off the market, or sell it to a buyer. Chances are that's not going to happen, right? Because normally when you got a tenant who you want to kick out before, because a buyer wants to buy it and move in, we're assuming that that's a tenant who's been paying rent, right? And what if all of a sudden they've been paying rent all along, and now you give them a notice that you've sold the house to a buyer who wants to live there. Then they say, oh, by the way, all of a sudden I have a COVID reason not to pay rent. And I swear that under penalty of perjury. I guess theoretically they could do that under the federal law. Tenants don't normally know about this federal law. You're not required to tell the tenants about this federal law. You're not required to give them the federal declaration. Here's what I'm really saying. You're in a situation, even after indefinitely, you have a buyer, you're listing a single family house. You have a buyer who wants to live there. You're in contract. Give the tenant the 30-day notice or the 60-day notice. If they don't leave, start the unlawful detainer. Just keep in mind, right at the last minute, if this tenant submits the federal declaration of COVID financial distress under penalty of perjury, you're not going to be able to complete the unlawful detainer. We don't see that been happening much, but it is possible. The federal law you have to think about, okay? So that complicates your life, okay? So that's pretty much the latest on COVID stuff. I'm going to answer some questions because they're good questions before I go on to other new laws, okay? I am going to get to Prop 19 in a second, so I'll go to that. 10 seconds, yeah, I'm going to get to some of this stuff. I think I've answered the question from Cheryl about the notice to terminate tenancies. By the way, since I was talking about PED form, can I use the PED form for more than one showing? You can, but think about what the PED form says. The PED form says to the listing agent, I'm not sick, I have no symptoms, I haven't been in contact with someone who's sick in the last 14 days. Well, okay, so ideally, a listing agent wants to see that you signed that either today or maybe last night, because if it's like 2 days old, they want to know your health situation right now, not 2 days ago. So I guess theoretically, you can tell a listing agent, yeah, that PED form, it's still true. What I said 2 days ago is still true. But the listing agent may say, yeah, but I want to see that in writing. I want you to confirm in writing that as of like recently, more recently than 2 days ago, you have no symptoms and you haven't been in contact with someone. So in other words, it's not that ideally the PED form is signed the day of the visit or the day before, right? I mean, theoretically, an old PED form is valid if it's still true. You see what I'm saying? All right. Very good question. Can a tenant on a property refuse to have any prospective buyers or tenants come and look at the property because they're worried about COVID? And the answer is no. We're all worried about COVID, but that doesn't give a tenant the right to refuse a showing. Now, if you lived in the city of LA, yeah, they have that right. But that's the only place I know in Southern California where you have that right. On the other hand, what if the tenant says, I'm over 65 and I have underlying conditions. I am particularly vulnerable to COVID. Based on that, I don't want people to come in. The law doesn't give them an exception, but my gut feeling is judges are going to say, well, if you're over 65 and you have an underlying condition, in a sense, you're disabled. So you have to reasonably accommodate a disabled tenant And some judges are going to say that means showing should be virtually or something like that. I'm just saying that's a possibility. But under the law, no, a tenant does not have a right a tenant does not have a right to refuse a showing, even because of COVID. A couple of you asked a good question. I said door knocking is not permitted. What about just dropping stuff off without knocking on the door? That is a gray area. Several of you have asked that question, and I cannot give you a definite answer. Clearly, mailing is fine. Clearly, door knocking is not fine. What about the in-between? The dropping off, but not door knocking? We're waiting sort of for a court case on that one. I mean, you can look at it two ways. You can say, well, that's not face-to-face contact. What's wrong with that? It's not specifically prohibited. On the other hand, the stay-at-home order says you should only be doing things that you can't do virtually. Why can't you just mail it rather than drop it off? It's not actually necessary, right? It's not actually necessary that you have to physically be there as opposed to mailing it or emailing it or whatever. So what I'm saying is it's theoretically possible that one of you's out there doing that, someone reports you and you get in trouble, and the DRE, they either report you to the DRE, they report you to the health department, and there's some type of case where they say, well, that violates the order. She shouldn't have been doing that. This has not happened, by the way. I'm just saying, you remember, I always give conservative advice. I always give advice when there's any risk at all. I always say, don't do it. So I'm saying, don't do it, if you ask me. But I cannot say that's definitely the law that you can't do it. You see what I'm saying? So sorry about that. Okay, let me keep going to more questions here before I go on, because these are all very important questions. Okay, the next question is, what if the seller and other occupants test positive? Well, obviously, on the PED form they give the listing agent, they got to disclose that. What do you do as a listing agent? Well, one question is going to be, has anyone been in the property in the last 14 days? You got to tell them you were in the property. Turns out the seller tested positive. That doesn't mean they were sick when you were there. They might not even have been there when you were there. But the point is, I need to tell you that. Okay. And then going forward, obviously, you're going to tell people the sellers are sick. They're probably not going to want to come in. But what about the seller was sick a month ago or 2 months ago? Do you have to still tell prospective visitors that the occupants of this property had COVID 2 months ago? You're going to hate me again, but it's another gray area. Most medical stuff says after X number of days, 14 days, or after 10 days after symptoms, you're not contagious. I don't want to be the test case when there's a lawsuit from a buyer who says, you didn't tell me the seller had COVID 2 months ago. So I would disclose that. How far back would I go? Gray area. I mean, it doesn't hurt to disclose. Say the seller had COVID 2 months ago. They haven't had mild symptoms. They haven't been sick since. You check out your own medical information, but I'm going to tell you that. I think a lot of buyers are going to say, okay, fine, thanks for telling me. I still want to see the house. I would still want to see the house. But I think the safe thing to do is to do that. Another issue, seller refuses to leave. I think you're talking about after they've been evicted, after the deal is closed. After the deal is closed, you can evict the seller, even if they have COVID. I mean, if the deal does close, the seller, just because they don't have somewhere to go, doesn't mean they don't have the right not to leave because of COVID. Even if they have COVID, they don't have the right not to leave. Okay, so tenants and plumbers, yeah. What if a plumber won't sign a PED? Well, it's up to the owner whether you're going to let him in anyway. The owner can say, you're not signing a PED, you can't come in. Some owners will say, what the heck? It's up to the owner, really, to let him in. Okay. I'm going to talk about rent increases in a second. and I think I talked about, you're buying a house with a tenant who's not paying rent. Now, the question is, are you buying a house because the buyer wants to live there? In which case, if the buyer wants to live there, remember what I said, you can evict the tenant. What if you're selling an income property to where the buyer's not paying rent? Well, obviously you got to disclose to the buyer, you're buying an income property with a tenant that's not paying rent. So, I mean, I think that's, unless I'm missing something, that's the answer to that question. And another good question, what do you do when you have an appointment to show at a specific time and 5 other agents show up? Well, you have to show up by appointment only, means they've arranged in advance, and it's got to be one buying party. So if it's 5 other agents, I'm sure they're not the same buying party. Have they submitted a PED form? Did they make an appointment? You don't show it to them unless they made an appointment in advance, submitted a PED form, and it's one buyer. They can't show it to several buying groups at a time or several agent groups. Or if it's a broker preview, each there should be an appointment made by each broker, right? Tenants and landlords have questions about this, you refer them to a lawyer. This is a very good idea. This is the type of area you try to avoid giving advice as much as you can. Nothing I said applies to commercial. Commercial, you can do whatever you want now. The commercial eviction, commercial rental rules, unless you're in certain cities like Culver City, the commercial rules are you can do whatever you want. Okay, all right. Judy Camp, the reason I was saying, the second reason you can evict someone right now is you want to take the house off the rental market. And by the way, all of these situations to evict a tenant, I'm assuming the lease is over. You can never evict a tenant until the lease is over. What proof does a tenant have to have that they actually have COVID? There's no proof. You got to take their word for it, basically. I mean, they sign this form, right? This declaration they sign under penalty of perjury. So if you find out later they were lying, you could sue them. They could go to jail, but you can't require the only time you can require the proof is if they're a high income tenant making a certain amount of money, then you can require proof that they actually have a financial hardship. Okay. Can a tenant be sued for back rent if they're still paying the 25%? Yes. You can sue a tenant for all the rent. It's just that if they're not paying 25%, you can actually evict them. Okay. Yes, the federal law supersedes this California law, which is why I said if they submit the federal declaration, then you're not going to be able to proceed with your eviction. Another great question. You're asking so many, I'm not going to answer quite all of them. I'm about to do other stuff in a second. Jason, good question. Can I give these forms to my clients, these COVID forms? Answer, no, unless you are the property manager or they're actually paying you, you have a lease listing. But if you just happen to have a client who's a landlord, under your agreement with CAR, you get free forms, but you cannot give them to your clients, okay? Tenant hasn't paid for 5 months. You can hire an attorney to try to evict them. If they didn't respond to the 15-day notice, yeah, you can proceed. Once again, they have an ace in the hole if they know about it. If they come up with the federal declaration, you're probably not going to be able to complete the eviction. Okay. I'm going to go on. I'm going to come back to questions, but I'm realizing there's so many questions. I'm not going to be able to answer all of them as I come in. By the way, all these good questions that you have, that's why we have a legal hotline. Please call. They will answer all of these questions. If I have time, I'll come back to more of these questions, but let me move on, okay? Let me go off of COVID. We could talk about COVID all day, obviously, but there are other new laws you want to know about. So let's talk about those. First, let's talk about Prop 19. That's a new law. Prop 19 says, I know I'm going to get questions. I'm probably not going to answer them because it's pretty straightforward. Prop 19 says 2 things. Number 1, it says if you're over 55, disabled, or a victim of a wildfire, you can sell your existing house, move anywhere in California, and take the property tax basis that you have in your existing house and take it with you, and your property tax basis at the new house will basically be the same as the property tax on your old house. Now, you can, if you're buying a house that's equal or lesser in value than your current house, you transfer the property tax that you're paying on your old house to the new house. If you're buying a house that's more expensive than your old house, you have to add to the property tax basis the difference in the price between the two properties. Let me give you an example. You bought a house a long time ago. You bought it for, let's say, $200,000. And now, because of the annual increases, the property tax basis is $300,000, but it's worth $1 million. You sell that house for $1 million. You buy another house for $1 million or less. What's your property tax going to be on the new house? It's going to be 300,000 basis. It's not going to be $1 million. It's going to be 300,000 because you're over 55, you're disabled, or you're victim of a wildfire. And you can move anywhere in California, and you can do this 3 times, even if you've already done it once under Prop 60, Prop 90. What if the same situation, bought it for 200, current tax basis is 300, currently worth $1 million, and I buy a new house, sell it, and I buy a new house for $1.1 million. What's the difference between your sell price of $1 million and the purchase price of $1.1 million? It's 100,000. What's my tax basis going to be on this new house I just bought for 1.1? It's going to be the 300 plus 100. It's going to be 400. That's a heck of a lot better than having your property tax based on 1.1 million. It's going to be based on 400. So Prop 19 is a good thing. It enables you to move anywhere in California 3 different times and take your property tax with you, even if the new house is more expensive than the old house. Now remember, even before Prop 19, we already had Prop 60 and Prop 90. That's still in effect. So even today, even before Prop 19, if you're over 55 or disabled, you could take your existing basis and buy another house in Orange County, LA, San Diego, Riverside, San Bernardino, or Ventura, or a couple of Bay Area counties, and transfer your property tax. What's new about Prop 19 is you don't have to stay in Southern California. You can move anywhere else. Number 2, you can do it 3 times. 3, you can even buy a more expensive house and still get a big benefit. Okay? Now, the question on Prop 19 is the effective date. It said in the proposition the effective date was April 1st. Does that mean I got to wait till April 1st to take advantage of this? Or can I sell the first house, my existing house, prior to April 1st? And then when I buy the new one after April 1st, then I can transfer the property tax basis. We think that's the answer. The general counsel to the Board of Equalization came out with a letter saying, yeah, you don't have to wait till April 1st. But the assessors are saying we need legislation to tell us this for sure. So CAR is sponsoring a law. It will hopefully get passed. We don't hear much opposition. It'll hopefully get passed quickly. That will clarify for sure that you don't have to wait till April 1st, right? You don't have to wait till April 1st to sell the first house before you buy the replacement property. But until we get that definite legislation, you can't tell your clients for sure that they can sell the first house now and buy and then buy the replacement after April 1st. We think that's the answer. It looks like that's going to be the answer. It's not the answer yet. Okay. But remember, under Prop 60 or Prop 90, you can do it right now. Under Prop 60 or Prop 90, you could move, transfer your property tax. You don't have to wait till April 1st because Prop 60 and Prop 90 are in effect until Prop 19 takes effect. And as long as it's within those counties I mentioned, and as long as the new replacement property is equal or lesser value, you can move right now and take advantage of this. Okay. All right. Okay. The other part of Prop 19, which people don't like, is the fact that Prop 19, effective February 16th, is changing the rules as far as assessing intergenerational transfers. Under current law, until February 16th, I could put in my will that when I die, I'm transferring my primary residence to my kid, and I'm also giving him another $1 million worth of real estate. And once he gets it, doesn't get reassessed upon that transfer upon death. Under Prop 19, this only works if I'm transferring my primary residence. I cannot transfer an additional $1 million. And the primary residence only works if the heir is also using it as a primary residence. And if the value of the property, let's say I got my house, it's got $500,000 tax basis. I put in my will, it goes to my kid. When I die, it's now worth 2 million as opposed to the 500,000. What's the tax basis going to be of the property when my kid gets it as a primary residence? It's going to be 2 million minus 1 million. It's going to be $1 million. So if the value at the time of the death is more than $1 million higher than the tax basis, then the tax basis is going to be the current value minus $1 million. So people are complaining, well, this is bad. How did this happen? How do we let this happen? Point number one, that's the only way the other part of Prop 19 was going to get passed. But more importantly, the legislature was already going to eliminate the intergenerational transfer tax exemption. There was already a proposed bill, and there was a lot of talk in the legislature that, California has a deficit now because of COVID. How are we going to close the deficit? Well, one easy way to do it would be to eliminate the intergenerational transfer exemption from property tax reassessment. So in my opinion, if Prop 19 hadn't passed, the legislature was going to take it away anyway. If you look at it that way, at least Prop 19 preserved the fact that a transfer of a primary residence to a kid or a grandkid who's going to use it as a primary residence, at least that is preserved as no reassessment. And also, I don't know. I also say, yeah, I mean, that's, in other words, that's in effect. And it's February 16th and that takes effect. So you're under the old rules until February 16th. Please don't knock off your parent or your grandparent before February 16th, just so you can take advantage of the old law. I don't think I recommend that as a practice. Once again, just kidding. Okay. So we do know the definite deadline on that one. That's a definite February 16th. We still don't know about the deadline for the portability of property tax. As soon as we know, we're going to email every single realtor. Okay. All right. One more thing related to this whole, and then I'm going to talk about other new laws, is there's good news for landlords. There's money coming. The bill that was signed end of December is going to send $2.5 billion to California for landlords. President Biden is proposing a new stimulus, which is going to send even more money to California for landlords. So what this means is, I'm a landlord, the tenant owes me back rent for COVID that they didn't pay. The government is going to give me money to compensate me for the back rent that my tenant hasn't paid me yet. Now y'all want to know, how do I apply for this money? We don't know the program yet. We don't know the process yet where you're going to apply. But that's, as soon as we know, you will know instantly. There'll be some state agency, you'll apply for the money. And by the way, it's only going to be eligible if the tenant, under the current law, if the income of the tenant household is less than 80% of the median income in the county. But I'm sure that's a lot of tenants. So let's say a tenant owes me 6 months of back rent, and this federal money comes in and I am qualified to get 3 months of that because they don't have enough money to pay everything. Well, now they give you the 3 months, and now the tenant only owes you 3 months, right? I mean, you can't go after the tenant for the back rent if the government gives you money for that back rent. You see what I'm saying? You can't double dip. Hopefully more money's coming. Hopefully there'll be less strings attached. We will let you know the details when we know. Just like we'll let you know the details of the Prop 19 deadline when we know. That's why you read your emails from CAR, because we tell you these things. All right, let's talk about other new laws that have nothing to do with COVID. Fortunately, there's not a lot of really important new laws. There's one real important one, and then there's a few that are pretty important. The number one important new law, other than all this COVID stuff in Prop 19, the most important new law is there's a law regarding home fire hardening. And there's a new law and a new form. There's a new disclosure form called the Home Fire Hardening Disclosure and Advisory, Form HHDA. There has not been a new mandatory form in California, new disclosure form, for about 15 years. In fact, for the last 15 years, if a realtor asked me, Gov, could you just tell me what are the mandatory disclosure forms? I would say, think of it like this. Think of it's NHD +4. As long as you order an NHD report, there's only 4 other disclosures you got to worry about typically. The TDS, the seller property questionnaire, the federal lead paint disclosure if it's pre-78, and then the 4 disclosure booklets, NHD +4. Well, for the last 3 weeks, when people ask me, what are the mandatory disclosures? I say it's NHD +5. There's a new one, the Home Fire Hardening Disclosure and Advisory. But you know what's different about this form? It's not required on every sale. It's only required if the house you have listed, residential 1 to 4, if it's in a very high or high fire hazard severity zone, and it was built before January 1st, 2010. So if it was built in the last 11 years, you don't need to do the form. And if the property is not in a fire zone, you don't need the form. You only need the form if it's both in a fire zone, built before 2010. So every time you take a listing now, you got to figure out 2 things. How old is the house? And is it in a very high or high fire hazard severity zone? Well, how do I know if it's in a zone? Well, remember, there are 2 possibilities. There's California, by the way, has very high fire severity zones, high fire severity zones, and moderate. You only need this form if it, or you're not in any zone at all. Culver City is not in any zone at all. Okay, so you got to figure out now, every time you take a listing for a house that's older than 11 years, am I in a fire zone, and what type of fire zone am I in? Okay, well, the NHD report that you already get, one of the categories in the NHD report is very high fire severity zone. So if that box is checked, you're in it, the form is required. What if that box is not checked? Well, there's another box on the NHD form that's called a wildland fire area. That really doesn't mean it's in a fire hazard zone. It just means it's in a wildland zone. Well, it doesn't tell you what type of zone it's in. So how do I know if I'm in a higher fire severity or a moderate fire severity or no zone at all? You have to ask your NHD rep. And most of the NHD companies I've talked to are going to, if they haven't already do it, they're going to incorporate into their reports a new thing where they are going to tell you if you're in a high. They already have to tell you if you're in a very high. But remember, this form is also required if you're just in a high fire severity. If you're in a moderate zone or no zone, you don't have to do the form. You're in a very high or a high, you got to do the form. So let's say I'm the listing agent, and yes, the house is in a very high or it's in a high, and it was built before 2010. What do I got to do? You simply have to give this form to my seller, to your seller. Isn't it the seller's job to figure out if the form is required? No, it's your job to figure out if the form is required. And then it's the seller's job to fill out the form. Okay, what this form does, it tells the buyer, there are three parts to the form. Well, first of all, the form tells you that when the form is required. So here's a question. If the form is not required, do I still give the form to the buyer telling them this form is not required? You can if you want, or I would just simply not give them the form, right? So you have a choice. You can actually give them the form and check the box, say, this form is not required. I don't have to give you this form. I'm just giving it to you anyway. By the way, why would you give someone a form you didn't have to? Because actually it has information that's helpful. It tells you about, how you can fire harden your home. Because even if you're not in a fire zone, you might want to take steps to make your house more resistant to fires. Anyway, but the form itself has three things. Assuming the form is required, part one of the form says to the buyer, hey, buyer, guess what? You're buying a house in a fire zone. You might want to think about improving your property to make it fire resistant. The second part of the form, the seller has to answer 6 questions. They have to tell the buyer if they have wood roof. They got to tell the buyer if they have combustible landscaping within 5 feet of the house. They got to tell the buyer if they have single pane windows. They got to tell the buyer if they have rain gutters without metal or non-combustible gutter covers. In other words, they got to tell the buyer that they've got features on their house that make it more vulnerable to wildfires than it would be if it didn't have these features. So this might come up in escrow. When the buyer gets it, they're going to say, oh, well, I think you need to fix the gutters before I want to buy your house. Who knows? The seller is not required to upgrade their house. They're just required to disclose to the buyer that their home has certain features. By the way, if the home was built after January 1st, 2010, then it had to follow the new building code. So it's got to have, it cannot have gutters with non-combustible materials. It cannot have a wood roof. It can't have single pane windows. That's why the form isn't required when you're selling a house built since January 1st, 2010, because the house was already built under the proper new standards. Okay. So as I said, the form, 3 things. General disclosure to the buyer, telling them, think about making improvements. Number 2, seller has to answer 6 questions. And the third thing that people have already been asking me a lot is, it says, there's a home fire hardening final inspection report. If checked, seller has obtained the report and they must provide it to the buyer. So people have been asking me, what is this home hardening final inspection report? The seller has no idea what that is. You're right. This is not going to apply in most cases. The only time this is going to apply is if the seller is the actual builder. Well, let's put it this way. If the seller is someone who's actually had fire damage and rebuilt the property since January 1st, 2010. So let's say I live in a fire zone. My house was built before 2010. I had a fire, I had damage, I rebuilt. Since I rebuilt, I had to rebuild it under the new rules, making sure the property was properly fire hardened. And when I did that, the local building official gave me this final home hardening final inspection report. Or if I have a pre-2010 home in a fire zone and I just did a major rebuild, even because there wasn't fire damage. If I did a major rebuild, I would have been required to comply with the new rules. So the only time, so if your seller asked you, what about this part? all you say to your seller is, are you the one who rebuilt this property? Did you actually do a rebuild on this property? And if they say no, I said, well, of course, then you're not going to have this final inspection report. Okay. All right. That's an important law. It's an important form. If it's a probate REO, it only applies to single 1 to 4. 1 to 4 does not apply to more than 4 units. Not required on probate REO or bankruptcy sales. Not required if the house is newer than January 1st, 2010. Not required on a trust sale unless the trustee used to be on title. Okay. All right. Before I go, that's the most important new law other than Prop 19 and COVID. Okay. By the way, getting back to Prop 19, you can buy the replacement house before you sell the existing house. You still have you have 2 years to do it. You can buy the replacement before you sell the existing. We just don't know if you have to wait till April 1st yet. Okay. Real quick, since you asked me the 3 reasons you can terminate a tenancy. By the way, normally single family homes, owner occupied duplexes, and buildings built in the last 15 years are completely exempt from the just cause rules. Part of the Tenant Rights Act that protects tenants from evictions also says single family, new construction, and owner occupied duplexes are not exempt from the just cause rules. That's why I said under current law, even on a single family home, you can only evict for 3 reasons, no fault. Number 1, I want to move in myself. Number 2, I'm taking it off the rental market. And number 3, I have a buyer in contract who's going to live there. Whenever this Tenant Relief Act ends, single family and new construction are going to go back to, you don't need any excuse to evict someone. You don't need any reason at all. But right now, not only are you restricted from evicting tenants with COVID issues, single family and new construction have to come under the just cause rules. Okay. So, related question, I may have just answered it from Pam. Yes. Can I buy the replacement first and sell the existing one later? Yes. We're just not sure yet if you can do either one prior to April 1st. Yes. Can I transfer properties to my kids prior to February 6th, prior to February 16 without reassessment? Well, of course, yes. If you pass away, if you're alive during your life, you can always transfer property to your kids without reassessment, right? I mean, that's still good. Even after Prop 19, you can transfer while you're alive real estate to your kids without risk. You may have a capital gains issue, maybe not, depends, but you can still do that. Okay. There are going to be more questions. I may have time for them, but let me talk about a couple more new laws that you should know about. Okay. You guys ask a lot of good questions. Harrison, thanks for pointing out that the deadline for recording documents, I'm not 100% sure, but you're probably right, February 12th. Because it's a holiday weekend that ends on February 16th. We're going to be issuing, yes, more advice on Prop 19 sooner rather than later. I don't know for sure. Yes, what I just talked about, the home fire hardening does apply to condos. Single family homes is what it applies to. The fire hardening, that's in effect right now. By the way, here's a question you didn't ask, but I forgot to mention. What if I went into escrow prior to January 1st? But it's in a fire zone and it's built before January 1st, 2010. So the law took effect January 1st. So I know if I have a new sale after January 1st, what if I had a sale prior to January 1st, but it didn't close before January 1st? Is that required? And the answer is, generally, laws are not retroactive. Unfortunately, this specific law doesn't specifically say that it's not retroactive. That usually means it's still not retroactive. What did I say a few minutes ago? I always give conservative advice. Am I 100% sure that this law is not retroactive? No. Therefore, I'm saying, even if you opened escrow prior to January 1st, to be safe, I would give this form to the buyer if the property's in a very high or high fire hazard severity zone and it was built before 2010. By the way, the fact that the property's in a trust doesn't affect these rules on intergenerational transfers and reassessment. Doesn't affect it at all. You can't avoid this by putting the property in a trust. By the way, when it comes to the rent cap just cause addendum, remember that was pre-COVID, but that's still in effect. Hopefully, every landlord last year gave their tenant the rent cap just cause addendum. Also, remember, if you get a new tenant, you still have to give them that form, but it's attached to the CAR lease form, so you can't miss it if you use a CAR lease form. But here's a question. I have an existing tenant on a lease. I gave them the RCJC when I signed them up on the lease. Now the lease is over. They're month to month. Do I got to give it to them again? No. What if the lease is over and I want them to sign a new lease? Guess what? You got to give them the form again, the RCJC. Anyway, you guys have got a million good questions that I'm not going to be able to get to all of them, but let's talk about a couple other new laws you should know about. So we've covered COVID, rentals, Prop 19, and the new disclosure form. Those are the most important things, but there are other important things. Here's an important one. AB 3182 took effect January 1st. Now, I live in an HOA. Maybe a lot of you live in an HOA. Here's the question. Can a homeowner association tell the people that live there, you can't rent out your unit? Or can they say only 10% of you can rent out your unit? Or can they say you got to live there 2 years before you can rent it out? Or can they say you can rent it out, but you can only rent it out to family members or something like that? Up until January 1st, yes, an HOA could have said that. Now, HOAs, the only thing HOA can do is they can limit the number of owners that rent out their properties to 25%. So they could do that, but they have to allow at least 25% of the unit owners to rent out their units, and they can't put any restrictions on who they rent to, or that they have to get to live there first. They could say, oh, we've hit the 25% limit. Nobody else can rent out your unit until we come down below 25%. They could do that, but that's the only thing they could do. Yes, Cheryl, RCJC is required on new lease or renewing lease. Okay, good question. Okay, so getting back to this 25%, you got that, right? What if I'm in a complex that currently doesn't have any restriction on renting out units? So 30% of the units in this complex already rent out their property. Well, and now the association decides to pass a rule and says no more than 25%. Well, they can do that, but everyone who's already renting out their unit is grandfathered in forever. But once it gets down to 25%, they could stop new people, right? Okay. By the way, this doesn't apply to short-term rentals. HOAs can absolutely prohibit short-term rentals. They can prohibit Airbnb-ing your property. They can prohibit less than 30-day rentals. That's true under the old law. That's true under the new law. Okay? All right. So that's an interesting new law, don't you think? And yes, of course, there is such a thing as a senior citizen complex. Cheryl and Marlene both asked a good question. Yes, then they can restrict it to people. You can also restrict who you rent it to as well, right? Okay. Yeah, there is such a thing as senior citizen. This new HOA law is state law. It's not federal law. Okay. Yeah, I answered your April question about the short-term rentals. Can an HOA require a minimum of 6 months tenancy? No, they really can't. They can't put any restrictions. Okay. They can limit it to 30. Yes. All right. Here's another new law that you're really going to find interesting. It's SB 1079. One of you already requested me to talk about it. I was going to talk about it anyway. Listen to this. There's a property in foreclosure. By the way, there's also a foreclosure I should tell you this. The president also extended a foreclosure moratorium, which is if you're a property owner and you can't pay your mortgage and you have a COVID reason why you can't pay your mortgage, you cannot be foreclosed on right now in California. Now, but wait a second, I thought the president is federal. Yes, the president said in his executive order that if it's a federally backed mortgage like Fannie, Freddie, FHA, whatever, no foreclosures for the next 2 months for people if the property owner has a COVID reason they can't pay their mortgage. But California law says all California mortgage servicers have to follow federal guidelines. And the federal guidelines are for federally backed loans. So in California, even if you have a non-federal loan, like a jumbo loan or something like that, you're still under the federal guidelines. So there's no foreclosures, at least for the next 2 months, if the reason the property owner can't pay their mortgage is COVID, which would also mean you have a tenant who's not paying the rent. This is the current president. President Biden did this. The previous president did the same thing, but it was expiring. So President Trump signed the order that was going to end of January. President Biden extended it. So whether you like it or not, both presidents did the same thing. It's only a question of it was extended. Okay. All right. The other thing that was extended is the right of forbearance. So not only do you have the right not to get foreclosed on, but if you own a property and you can't pay your mortgage for a COVID reason, you're entitled to go to your servicer, the person who's collecting the money, and say, I want to go into your forbearance program, which means they have to give you at least a 6-month delay on making the mortgage payments that you can't pay because of COVID. And after 6 months, they have to give you an additional 6 months if you need it. So property owners, it's not just tenants that have certain rights. Property owners have certain rights too. The tenants' rights are not to pay rent sometimes, but remember, it's not that they don't have to pay the rent, they just can't get evicted. They still owe you the money. And hopefully there's going to be federal money coming to compensate the landlords. The rights of the property owners are, well, hopefully you're going to be getting some of this federal money for your tenants who aren't paying, but also it's got nothing to do with a tenant. You just can't pay your mortgage because of you lost your job, you're sick or something. You have the ability not pay that payment, but you have the ability to have that payment delayed into the future. Okay. All right. Let's get back to foreclosures. Are foreclosures legal now? Of course they are, as long as it's not someone with a COVID issue. So let's say there's a foreclosure on a residential property. So I go to the foreclosure sale and I'm the winning bid. I win. Yay, my house. I just foreclosed. I got the property. Well, guess what? If I'm an investor, it's not my property yet. Listen to this very carefully. If you foreclose on a residential property, let's say there's a tenant there. I'm foreclosing on a property with a tenant living there. That tenant now has 15 days to notify the trustee that they want to buy the property that I just foreclosed on. If they submit that within 15 days, I have to give them an additional 30 days to come up with the financing to buy it. But if they notify the trustee within 15 days that they want to buy it, and they can come up with the money within 30 days after that, it's theirs. They pay me. In other words, it's not really my property for 45 days, because if there's a tenant there, they have a right of first refusal. Now, if I, the person foreclosing, if I plan on living there, they don't have a right of first refusal. It's only if I'm an investor and they want to stay there. But there's another part to this. I'm an investor, there's no tenant there. But since I'm an investor of this residential property, anyone else out there who wants to occupy it, or even a nonprofit housing provider that provides property, they have 15 days to submit a bid to buy the property that I just bought at the foreclosure sale. They would have to bid more than I bid. And if more than one of them bids, whichever bids the highest, they get it. And then they have 30 extra days to close. You think about it, why wouldn't they just go to the foreclosure sale and bid at the foreclosure sale? Why would they have waited until it was foreclosed on? Because then they have to bid more than that. Who knows why? The point is, though, under this law, SB 1079, if you foreclose on a residential property and you're not planning on living there, then you don't know for sure if you have it for 45 days. So what about the person who used to own the property and they were foreclosed on? After the foreclosure sale, can they now bid? Well, yeah, they could. You'd think if they had the money, though, they would have stopped the foreclosure sale, right? You know what I'm saying? How much do they pay? It's a bidding process. The tenant only has to match the price. Okay. By the way, Len Herman, how long do you have to live there not to be an investor? SB 30, I think you mean SB 38, not 39. The idea of, so we're talking about I'm not sure what issue we're talking about. If we're talking about the issue of inheriting property, you have to use it as a primary residence. You have to live there indefinitely. If you inherit it and you're using it as a primary residence and you're going to use it as a primary residence, but then 5 years later, you're going to rent it out, you're going to get reassessed. Okay. By the way, Kendall, the website of the trustee has to have all this information on what the price is. So you can always go, anyone, a prospective owner occupant, the tenant can always go to the trustee's website, and there's a 24/7 number you can call. You can find out what the price is and what the rules are of doing it. Okay, so that's an interesting law. I think you'd agree. Let me talk about one more interesting law, and then I think I'll be able to go back to some questions. Maybe a couple more. Oh, by the way, related issue, people say, can I still increase the rent? Yes, you can still increase rents now. How much can I increase them by? Well, for one thing, there have been a lot of wildfires last year, and some counties or parts of some counties are still in a state of emergency. I forget if Orange County is in a state of, I don't think it is. If you're in a county with a state of emergency, you're limited to 10%. You can increase someone's rent. Let's say you're not in a county with a state of emergency. How much can you increase someone's rent? Well, if it's a single family or new construction, you can increase it as much as you want. If it's the building's older than, or an owner-occupied duplex. If it's something else, then you can only increase it by 5% plus inflation, right? Just inflation. What's the inflation rate? It depends on the county that you're in. We have a Q&A on our website that will show you exactly what this year's, if you call the hotline, anyone, I could look it up also. What is this year's inflation rate in Orange County? In other words, if you're not a single family, not 15, the building is not new construction, and it's or not an owner-occupied duplex, you are restricted on how much you can increase someone's rent to 5% plus the inflation rate for the region that you're in. Okay. Okay. So that was something I wanted to, AB 3088. I did want you to know that one. That's part of the COVID law, that this rent cap thing. And there's a lot of good explanation about how do you figure out how much I can increase my rent. There's an explanation there. You basically have to look at the inflation rate the previous year versus the current year, and what's the difference. That's how much you can increase the rent. Call a lawyer if you have any doubt in your mind. Call the CAR if you want to know how much you can increase someone's rent. Okay, different issue. All right, here's another interesting new law. Good news. I finally have really good news for you. The homestead exemption has gone up for everybody. What is the homestead exemption? Homestead exemption means when you buy a house, principal residence, you buy a principal residence, you're automatically protected. Your house is automatically protected from someone, a judgment creditor, from foreclosing on your house unless they have enough money to pay you your homestead amount. Let me give an example. And the homestead amount prior to this year was $75,000 if you're single, $100,000 household, $175,000 if you're over 65 or 55 and older and disabled. Let's talk about me. I live in LA County. Prior to this year, head of a household, so I have a $100,000 homestead. And let's say my mortgage, I have $200,000 left. So I owe my bank $200,000. I have a $100,000 homestead. That means if somebody sues me and they get a judgment against me for $280,000, they couldn't foreclose on my house because the judgment doesn't have enough money to pay off my lender $200,000 and pay me my $100,000. But if they got a judgment against me for $500,000 last year, they could have foreclosed on the house, paid my lender $200,000, paid me $100,000, and they keep the other $200,000 because that was my homestead amount, $100,000. Well, guess what? As of this year, the homestead amounts go up for everyone, regardless of single household, 55, 65. It goes from $100,000 to $300,000, or the median sales price in the county you live in the previous year with a cap of $600,000. What was the median sales price in LA County last year? It was over $600,000, which means I now have a homestead in my house of $600,000, which means, and I owe let's say I owe my bank $200,000. That means even if someone sued me for $799,000 and got a judgment, they couldn't foreclose on my house because they don't have enough to pay me my $600,000 in addition to the amount they got to pay the secured creditor. I don't know what the Orange County median sales price was last year, but if it was over $600,000, every single person who owns a house in Orange County currently now has a $600,000 homestead. If it was less than that, whatever that number is, that's your homestead. Okay, so that's interesting, wouldn't you say? Good news there. That's good news. Let's see. I've talked about most of the really important laws I think you need to know about. As you can see, there's not a lot of new ones, right? Would you agree? There's not a lot of new ones. There's all this foreclosure and rental stuff that's important. But other than that, there's not a lot, but a lot of this stuff is in flux. What's going to happen with these forbearances? What's going to happen with foreclosures? What's going to happen with evictions? When is Prop 19 going to actually take effect? When is that federal money that's going to compensate me for my tenants who didn't pay, who owe me rent because of COVID? When and how am I going to get access to that money? Those are all things that we don't know yet, but we're going to find out soon. And that's why you're going to keep reading your emails from CAR, and I'll come back and do this again. I'll do it more often than I used to do it. Let me try to do some questions real quick. I'll go in reverse order this time. And and I'll stay as long as you want if you want me to stay longer. Okay. What if you own a home with a child 50-50 and the child gets sued? Well, yeah, there's a total. The question is, you share the homestead amount. They can't. Let me rephrase that. If it's actually owned 50-50, each person gets the homestead. So it depends on the amount of judgment. And theoretically, they could foreclose on the child's portion, or forget a child. If more than one person owns it, theoretically, they could get a huge judgment against one of the people and foreclose on that person's portion of the house. Okay. Steve Craig, you're right. I didn't mention, by the way, what about form changes? The only new form is the home hardening form I mentioned. The other new form that came out a couple months ago was the Fair Housing Addendum and Advisory. Remember, that's attached to all purchase contracts, all leases, all listing contracts. Strongly recommended you make your client sign that form. By the way, most of the attachments to the purchase contract, they're for the buyer to sign. But this home hardening form, you should have if you're a listing agent, you want your seller to sign it and the buyer to sign it as well. And same thing with the fair housing form. That's information you're giving to the seller and the buyer. So hopefully when you take the listing, you have your seller sign the fair housing addendum. And when you're the buyer's agent, you have your buyer sign it. But what if you're the listing agent at the time of the listing, you didn't make your seller sign the fair housing? Then make them sign it at the time of the sale. Remember, the fair housing form simply educates people on the fair housing rules, which have changed recently, and advises people of the risks of certain practices, such as buyer love letters, where the buyer tells the seller that they're married, they have kids, where they're from, how old they are. Because remember, seller is not supposed to make their decision based on personal characteristics of the buyer. So I don't really want to know how old you are, how many kids you have, whether you're married or not, because that's information I'm not supposed to use to determine whether I'm going to sell you the house. And I don't want to be accused later by someone saying, well, you didn't sell me the house because I had kids or I didn't have kids. Anyway, the other form that changed with the COP form, it didn't really change significantly. Remember, you're making an offer to buy a house. You want to make your offer contingent on selling your existing house. You submit the COP form. That form says that if I can't sell my existing house, I don't have to buy your house. It also says if my house doesn't close when it's scheduled to, you can cancel me after giving me a 2-day notice. It also says if the seller gets a backup offer, the seller can give the buyer 3-day notice to remove this contingency and their loan contingency. What has changed on this form? 3 things. A buyer can now say to the seller, my offer is not contingent on closing the sale of my existing house. My offer is just contingent on getting my existing house into escrow within the next 17 days. Which means if the seller accepts that, if the buyer's house doesn't close, too bad for you, buyer. That's not a contingency anymore. You're going to lose your deposit. But it also is good for the buyer because that means that the seller can't cancel the buyer if the buyer's house doesn't close on time, because the buyer's offer wasn't contingent on the house closing on time. It was just contingent on entering escrow with their house. Who knows if a seller's going to accept that or not. Second thing, this form now requires the buyer that if the seller asks them, the buyer has to keep the seller updated on the status of their sale escrow. In other words, the seller can say, by the way, has your buyer removed their contingencies yet? Have they asked for this? Have they asked for that? And you would have to tell them. And the third change on the form is, remember I said if the seller gets a backup offer, that you can give the buyer 3-day notice to remove this contingency and their loan contingency. What form do you use to notify the buyer that this happened? Well, now you can actually use the COP form itself. That was very quick, but that's your forms update. What about the purchase contract? It's going to be changed next December. So I'm already scheduled on the OCAR calendar, I know, to teach a class on the new purchase contract at sometime in the fall. So you'll all be ready, and I'm sure I'll do more than one class and we can do it over and over again. But no changes to the purchase contract till end of December. Here's a very good question. Remember I told you about that new homestead rule? Do I have to record the homestead to get this protection, or is it automatic? It is automatic, but record it anyway, because by recording it, you get additional protection. Not only are you protected from foreclosure, but you can actually sell the house and the lien won't attach to the proceeds either. Okay? You guys are asking so many good questions. I'm not saying, Steve, you shouldn't have the buyer write the letters. I'm saying as a listing agent, you should have a conversation with your seller and say, based on this analysis, do you still want these letters? Because receiving these letters may make you more vulnerable to a fair housing accusation. The seller might say, I don't care, I still want the letters. What if you're the buyer's agent? Do you advise the buyer to write the letter? Well, if the listing agent put in the MLS, they don't want these letters, no. What if they didn't? I mean, it's a judgment call. I would talk to my buyer and say, well, these letters, seller may not want them for various reasons. And you can point out to the buyer that section of the fair housing form that discourages them. But if they want to write them, they write them. It's really up to the buyer and seller ultimately. Okay. We are almost done here. You guys can cut me off whenever you want. Homes, only primary residences apply for the homestead. And you can only have one primary residence at a time. Okay, so yeah, if it's second home, you do not get the homestead protection. What about the Prop 19? You leave your house to 2 kids. Do they both have to live there to avoid reassessment? No, only one. They don't both have to do it. Yeah, so once again, the buyer love letters, you understand the concept. The reason you might want to discourage them is only because it adds to the risk to the seller to be accused later of discrimination on the grounds that they were discriminating based on the buyer's personal characteristics. So bottom line, for that reason, you have the conversation with your seller, okay? Can a listing agent refuse to present the seller? Not if their seller says, give me the letter. You have the conversation and they may say, yeah, I think you're right. Maybe I shouldn't do the letter. But if they say, thanks for telling me that, I still want the letter, you can't, you know what I mean? You don't deny you can't deny the letter. Yeah, Amy Caves, why don't you email me? You guys can all email. I can give you my address, govh@car.org, or call the hotline. Let's see. The square footage form, that's a relatively new form. Remember when the SFLS, square footage lot size advisory, remember when you sell a house, you have to tell the buyer what the square footage is? But you also have to tell them where you got that number. And if you're aware of more than one number, like the appraiser thinks it's one number and the assessor thinks it's a different number, you got to give the buyer both numbers and you got to tell them where you got the numbers. So the point is we now have a nice form with a little grid on it where you can make that easier. So I recommend the form. It's not required by law. SB 1079, Sherry, was the one about the, I forget the numbers myself. That's the one where the first right of refusal by owner occupiers and tenants following foreclosure sales of residential property. Okay. You can remember I only homestead one unit, right? You only have one primary. Well, I own a duplex and I live in both. Well, you only can live in one. Okay. You only have one primary residence. Okay. Derek, don't know anything currently on 1031 changes. I could look it up, call the hotline. Yeah, record the homestead if you can, but even if you don't record it, you're still protected. Yes, you can, Joyce, you can, single family homes, including condos, are exempt from the California rent control but you might be limited by the anti-gouging law in effect if your county is still under one of those states of emergency based on the fires, okay? Frank, what if the property is a condo with leases month to month? Sorry, I wasn't sure what that's referring to. Claudia, Gas, very good question. On that home hardening form, what if the seller says, I don't know the answer to these questions? You would think the average seller would know if they had a wood roof or not. You would think the seller would know if they have single pane or dual pane, but if they're like me and they don't know anything about property, maybe they wouldn't know. Yeah, they only have to disclose what they're aware of. So I'm just wondering if a judge is going to say, how could you have not been aware of that? I don't believe you. You know what I'm saying? So maybe you ask a contractor just to be safe. You know what I mean? But it does say the seller has to disclose if they're aware. And what if it's a seller doesn't live there? It's residential, but they don't live there. The form is required. Seller could say, I live in Arizona. I've never seen, I don't know what it has. Yeah, legitimately, they don't have to investigate. You're right. This tenant right to purchase is California law, not federal law. I think we talked about yeah, good comment. Someone says, isn't Prop 19 just deferred reassessment? You're right. Even if you transfer your primary residence to your kid, unless they live there forever as their primary, at some point, you're right. If they turn it into a rental, it will get reassessed. Remember what I said though, you can quote me, I strongly believe that this was going to go away. The tax, the non-reassessment of intergenerational transfers upon death was going to go away anyway. Prop 19 actually preserved it, at least for single family homes, if you look at it that way, right? Okay. Beryl, good question. I just told you that HOAs can prohibit short-term rentals, but you're in an HOA that has not prohibited short-term rentals. So you're currently renting it out on short-term rentals. Now the HOA says no short-term rentals. You're still grandfathered in for what you've already got going. But does that mean I'm already grandfathered in for, they're not currently living there, but I have a contract for a short-term rental in the future? This is one I'm going to have to say I'm 99% sure that they're grandfathered in. I just can't guarantee 100%, but I think you are. Okay. Very good question. Licensed agent performing management duties. Remember what I said, you can only give these forms to your clients, the rental forms, if you are actually the property manager or you actually have a lease listing. So I don't understand the question. The question is, a licensed agent performing management duties for the form where the property owner is managing themselves. Well, who's managing, the agent or the owner? Maybe they're sharing it. If the owner's managing and getting paid for that, you can give them the form. Otherwise, you can't. And it looks like Lisa is back, which is probably telling me to stop. I think I got most of the questions, believe it or not. You have the hotline for the ones I didn't get. You can even email me. I will get back to you, not as fast as the hotline, at govh@card.org. So Lisa, I'm going to stop.
You could go all day, Gov.
Probably could.
So much good information. We even had, a post of, best webinar ever. So, that's pretty good praise there. And Lori would wrap this up, but she's having a little bit of technical difficulty right now. So I'll just have to take over for Lori, who I want to thank immensely. It's an honor to have her here hosting. There she is. There she is. I'll let her speak.
Oh, well, no, you're doing a great job. Thank you, Gov. I mean, I have heard you speak on these topics for a few months in anticipation of January 1st, and every time I learn something new. So thank you. We are indebted to you for your time and your wisdom. Really appreciate you.
My pleasure, and I'll come back soon. You don't have to wait a year, so just. Call me in a couple
Take you
months.
up on that.
I'll come back.